Imagine a property developer holding a large parcel of land. To generate immediate capital, they split the estate and sell off a large, dilapidated country house sitting on a portion of it. That is exactly what Bluebell Homes did. They sold the country house to Darren Fisher, who converted it into the gray brick hostel. Bluebell then developed the retained acreage and sold those new houses to a group of homeowners. Eventually, Fisher retired and sold his hostel to a company called Broadland Ltd. When Fisher first bought the land, Bluebell Homes required 3 strict promises in the transfer. Fisher agreed to allow only sole occupancy in the hostel rooms, to prohibit public events in the hostel grounds, and to contribute to the maintenance costs of a shared driveway. Now, years later, the homeowners face a crisis. Broadland Ltd. is crowding families into single rooms, throwing loud public events late into the night, and flatly refusing to pay for the decaying driveway. The homeowners need to stop this, which brings us to the central legal conflict. The homeowners want to sue Broadland Ltd., but contract law presents a massive roadblock: the doctrine of privity. The homeowners didn't sign the contract, and neither did Broadland Ltd. Under strict contract law, they cannot enforce these promises against each other. In land law, the person making the promise holds the burden. They are the covenantor. The person receiving it holds the benefit, the covenantee. These are equitable interests, so Section 53(1)(a) of the Law of Property Act 1925 requires signed writing to create them. Because privity blocks a standard contract claim, solving this neighborhood dispute requires us to figure out if the benefit and burden can legally attach to the land itself, passing to future buyers. To do that, we have to build an enforcement matrix. We evaluate the transmission of the benefit and the burden through 2 parallel systems: common law and equity. Let's start with the common law. Passing the benefit is straightforward. It passes to successors through express assignment or automatically if it touches and concerns the land and the parties intended it to run. But the common law hits a brick wall regarding the burden. As established in Osterberry v. Oldham Corporation, the burden of a covenant does not run at common law. You simply cannot force a contract onto a third party who didn't sign it. This diagram from the text shows the primary workaround the industry uses. Sellers require buyers to enter into an indemnity covenant. The original covenanter remains liable, but if sued, they seek reimbursement down a continuous chain of buyers. The flaw in this system is severe. The burden never actually passes to the land. If any single party in that chain goes bankrupt, dissolves as a company, or simply disappears, the chain breaks. The financial safety net vanishes entirely. There is one narrow exception, allowing a burden to be enforced against a successor at common law: the doctrine of mutual benefit and burden, established in Halsall v. Brazel. The mechanics are highly specific. If a successor in title wishes to exercise the benefit of a right granted in a deed, like an easement to use a road, they must accept the connected burden contained in that exact same deed. The House of Lords later restricted this rule in Roan v. Stevens. The financial burden must be directly related to the exercise of the specific benefit. You cannot bundle unrelated restrictions onto an easement and expect them to stick. For exams, keep this rule absolute. Never attempt to pass the burden of a positive covenant at common law. If you see a positive promise, immediately scan the facts for a linked easement to apply the Halsall exception. Because the common law refuses to pass the burden to the land, we have to look to the bottom row of our matrix: equity. Equity's intervention traces back to 1848 in London's Leicester Square. A man named Moxhay bought land with clear notice of a covenant to keep the central garden open. Because he wasn't the original buyer, he argued the common law protected him and tried to build on it anyway. The court found this unconscionable. This gave us the landmark case of Tulk v. Moxhay. Equity will enforce a burden against a successor in title, provided 4 strict conditions are met. Condition 1. The covenant must be negative in substance. Equity uses a substance over form test. To keep the land as an open space sounds positive, but it restricts building, so it is negative. Not to let the property fall into disrepair sounds negative, but it requires the owner to spend money on upkeep. If you have to put your hand in your pocket, it is positive, and equity will not help you. Conditions 2 and 3 require that the covenantee owned land capable of benefiting from the promise, and that the original parties intended the burden to run with the land, an intention usually implied by Section 79 of the LPA 1925. Finally, Condition 4. The restrictive covenant must be properly protected by registration on the appropriate charges register before the successor buys the land. To complete the matrix, the equitable benefit runs easily. Section 78 of the LPA 1925 operates to statutorily annex the benefit of a covenant to the land, passing it to successors automatically, a principle confirmed by the Court of Appeal in Federated Homes. These tables from the text outline the complete matrix. The rules for the benefit are highly permissive in both systems. The rules for the burden are rigid. When building a legal claim, you must observe the rule of symmetry. You cannot mix and match legal lanes. If you are suing a successor in title for breaching a restrictive covenant, you are relying on the burden in equity. Therefore, you must prove that you hold the benefit in equity. Strict adherence to these horizontal lanes is mandatory. You must stay entirely within the rules of common law or entirely within the rules of equity. Returning to the Bray-Brick hostile conflict, this diagram maps our specific parties onto the matrix. The homeowners are successors to the original covenantee. Broadland Limited is the successor to the original covenantor. We analyze the first two breaches, the overcrowding and the public events. Applying the substance over form test, we find both covenants are restrictive. They dictate what cannot be done on the land and require no expenditure. Because they're restrictive, we use the equity lane. The burden runs to Broadland Limited under Tulk v. Moxay, and the benefit flows to the homeowners via Section 78, completing the connection. The third breach is the refusal to pay for the shared driveway. This requires Broadland Ltd. to spend money, making it a positive covenant. Because it is positive, it fails the Tulk v. Moxay test in equity. Because it is a burden on a successor, it fails the Osterbury rule at common law. The direct matrix pathways are blocked. Here we look for an attached right. The original deed granted a right of access, conditional upon paying for its upkeep. We can deploy the Housall v. Brazel exception. The homeowner's path to resolution is clear. They can seek an equitable injunction to immediately halt the overcrowding and the late-night parties. For the driveway, they can block Broadland Ltd. from accessing it until the bill is settled. Enforcing promises against successors requires precision. You isolate the promise, classify it strictly as positive or restrictive by looking at its substance, and route it through the correct legal or equitable lane to find your remedy.